join us today on our quarterly review of the commercial and ag lending disputes for Q1 2024. I'm Mike Fielding, a partner here at the Husch Blackwell law firm. We still have people joining, and I have these opening housekeeping items that we need to cover first off. So let me hurry and quickly get through this, and then we'll dive into the meat of the program. At the bottom of the audience console, you will see multiple application icons for your use during the program today. If you have any questions during the webcast, please submit them in the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or if we run out of time, then one of the three of us can follow up with you via email. A PDF of the presentation is available in the program materials folder. For those of you who are attorneys, this program has been approved for legal education hours. For live attendees, you will report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing or putting young children to sleep if you need to. And then toward the end of the program, we'll be asking you to complete a short survey. We really appreciate the feedback that we get on these programs. We are always looking for ways to try to improve them and frankly make them better. And so with that, let me just give a super quick overview of what we're doing, the genesis of this webinar, and then we're going to dive into the materials. So some of you that have listened to the program know the methodology here. So every single day I get about 3 or 4 different emails from different sources, and they're dealing with distressed commercial and ag loans. And I look at them, and then when I see interesting cases, I just kind of set it to the side and then print it off and then digest it. And then we come up with the materials here, and we try to do it in a quick Q&A format. This past quarter, it's been tough in 2 regards. One regard is there's just been a ton of cases that came out, and we're going to talk about 16 here. And frankly, I've got a pile of cases about that big sitting on my credenza in my office that I just haven't gotten to yet. We will be covering those in the June webinar. And then the second point was my son, he died in an accident. He was 19 years old. He died 2 months ago today, actually. And that obviously dealing with the grief and everything, that really slowed me down as well. And I do want to say, I know some people have sent thoughts and prayers and well wishes, and we greatly appreciate that. The other point I wanted to make here, and this will sound a little bit silly, maybe even a little bit preachy, but there's a really important principle here I want to articulate, and that is when you get into a swimming pool, like when you're taking swimming lessons, you may just be focusing on one stroke or one crawl, and then after a while it becomes very natural, so that we could, so to speak, throw you into a swimming pool. You could be playing around and you can just immediately move from one stroke to another, because you've been able to quickly understand how to move in the water and when to do certain strokes and when not to do that. The principle here that I want to mention is that we're going to cover a lot of different legal issues today, and some of these issues may not apply to you directly, but and sometimes people will say, well, it doesn't apply to me today. The point here is that when you're dealing in just the lending world, you come up with a lot of really unique situations and nuances. And even though a particular case may not directly apply to you, what you may happen, for example, is you may find a principle or an idea, and we want to expose you to it, get you familiar with it. It's kind of like exposing you to a particular swimming stroke, getting you understanding how it works, so that when you're thrown into a situation where you can suddenly realize it, you have the memory of it, and you can kind of jump to it and work with it. For example, quiz number 12 today, it's going to deal with marshaling, something that doesn't happen typically, but it's one of those in the right situation that can actually be a really, really great argument. Okay, I'm rambling too much. Let's move on with our first quiz. Before I get to the quizzes, one last thing. Joining me today, we have Tom Donaldson and Chris Miles. They're both my law partners here at the firm. Tom's a top-notch attorney. He deals with loans on the front end, documenting them, doing everything, dealing with the loans when everything is going hunky-dory. And Chris and I, we work closely together when loans are on the back end, when everything is crashing down, things are not going well, when it's a distressed debt, distressed credit, bankruptcy, that sort of thing. So, all right. So with that, we're going to turn it over to Tom. Tom, you've got quiz number 1.
Great. Thanks, Mike. And yeah, I was never much of an athlete, definitely not a swimmer. That's why I ran cross country in high school. I was able to put one foot in front of the other, but don't throw a ball or anything at me. I was no good at that. All right. Well, let's start with quiz number 1. And those of you out there who like strict interpretations, this one's for you. The question is that the bank issues a letter of credit. The letter of credit provides that it's payable on presentment of the original and all amendments to this letter of credit. Apologies for the typo, to this letter of credit for endorsement. An amendment was issued, and when it was presented for payment, the beneficiary did have the original letter of credit, but did not have the amendment. So the bank refused to honor the letter of credit. Beneficiary sued. Who wins? I previewed this in my remarks. The answer is the bank. In this case, the court required a strict compliance with the terms of the letter of credit, and those terms said that both the original of the letter of credit along with any amendments that were issued had to be delivered in their original form. In this particular case, clearly the beneficiary wasn't able to produce the amendment, and in fact, they came up with what I would equate to a lost note affidavit. It was, well, I suppose, a lost letter of credit amendment affidavit where they offered up that they didn't have it and would provide an indemnity and everything you would see in a case where a promissory note was lost. And that still wasn't enough. In this case, the court looked at the very strict meaning of the letter of credit, and it said the original had to be provided. Just another item of note, that I noticed when I was looking at this case is different copies of the amendment were provided. The bank actually had a slightly different copy than what the beneficiary had, and I think that was one point that the court looked at to sort of bolster their decision in this case. So, the takeaways, of course, don't lose your originals. That's the main one here. And also just to closely look at your letter of credit terms. Make sure that when you are submitting an LC for payment that you're following the rules. With that, I believe I'm going to send it over to Chris.
All right. Quiz number 2. Expert valuation reports can be very expensive and time-consuming to generate. Can a party use AI, artificial intelligence, to generate a valuation report that will be admissible in court as evidence? And the answer, unsurprisingly, at least right now, is no, and it was not in this case. And it might be better termed no, not yet. This particular case, we had an expert who had an AI-generated report. He testified that he'd spent 72 hours on the project when, if he had done all the work, it probably would have taken 1,000 hours. The court wasn't particularly impressed by that. It held that the report had no citations to any facts or data, that the testifying expert didn't review the underlying source material and wasn't aware of how the material was assembled or reviewed. There were no standards governing the use of AI, and the report contained various errors. The court also noted that the valuation method that was used was not peer-reviewed. And the reason is this was a cryptocurrency token case, relatively new type of asset. And Mr. Farage was the expert here. He had developed this methodology, and of course it hadn't had it peer-reviewed. But oddly enough, right after the report was thrown out, the court did allow Mr. Farage to testify as an expert. So I think what we can take away here, other than the key takeaways that you see on the screen, are that courts in the future may be a little more willing to accept these types of AI-assisted or generated reports, especially if they don't contain errors, if they actually have citations, given, again, that the technology and the valuation as an asset is a relatively kind of the new kid on the block, if you will. And so this is something we should all be keeping an eye on. But again, I'm probably more in the AI skeptic camp. You know, I've been told for 10 years self-driving cars are happening next year, and I'm still waiting. So I think AI might be oversold in some cases, but again, it's something we want to keep an eye on. And so I'll turn it over to Mike.
And I guess, Chris, before you go on and make a couple quick comments on that, I think we need to maybe put this into a couple different buckets. One bucket is you get the expert report, but then another bucket is what about the use of AI internally at the bank for valuation and everything else? And I guess where I'm at it in this camp is, you know, I hear what Chris is saying. I think we've all been a little bit underwhelmed by AI at times, but then I've seen some of the product from AI, and some of it is actually pretty impressive at the speed at which it's done. And so I think on the one hand, you need to be skeptical, but at the same time, be working to try to adopt it as well. And what we would expect when you get into the expert realm is maybe not an all or nothing approach, but what I'll call more a sequential approach, where you have an expert who then takes AI and says, hey, the AI generated machine went out and dealt with grabbing particular pieces of data very efficiently, and then incorporating that into the report. I think reports using AI in that regard will be maybe less suspect in that type of situation. So anyway, more to be seen on that one. All right, this one, you're going to laugh at this next quiz. So this happened up in Minnesota. You have an overzealous, you just imagine yourself as a bystander in the parking lot viewing this one. You have this overzealous repo agent. Hey, we got to get this car. The car owner, no, don't take my car, that sort of thing. So the car owner goes and gets inside of the car. The repo agent blocks it so the car owner can't leave. And then apparently the car owner or the repo agent physically or hooks the toe up to the car and starts lifting the car up while the person is inside. The blockage occurs for 30 minutes. Ultimately, lo and behold, the lawsuit comes out of this, and the claims are for breach of peace and conversion. And the question is, has the borrower stated a viable claim? And I guess we could really put that into a part A and part B. Is it a viable claim for breach of peace, and is it a viable claim for conversion? What do you think? Well, I would think it is breach of peace, and the answer is yes, it is breach of peace. This involved this Hansen v. Santander Bank, and you can see here on the screen that the court applied these 5 factors to determine whether or not breach of peace was occurring. And obviously, anytime you're trying to get a piece of collateral and the person is inside of it, that's just like a lawsuit waiting to happen, right? And you're sitting here, what was that person thinking? And so we can, and obviously this is in a consumer context. Consumer cases sometimes I think can go to real extremes. Obviously we're here focused on commercial matters and ag-related matters. And so the question is, how can we apply this to ourselves in our particular scenario? And I think there's a few key takeaways here. When you are engaging somebody to pick up the collateral, you want to use somebody that's reputable. And the risk you run is if you have, just Larry and his repo agency group are going out there, if they're using overly aggressive tactics, that can come back to haunt you because they will be viewed or deemed to be your agent. So you really want to be careful about that. Now, that being said, if you have the opportunity to pick up vehicles, like let's say the car owner had gone into the restaurant and was just in there for a long meal, and the repo agent just comes to this public spot, picks up the car, probably don't have a breach of the peace right there. The interesting question here is on conversion. The court says, no, there's no conversion claim that occurred. Conversion, just so you know, you're temporarily deprived of use of the property. And the court is saying, hey, 30 minutes, you really weren't deprived of it, so we're not going to let you get hit by that one. Personally, I think because of these breach of peace issues can be really messy, I think a better approach is when you are in, hopefully you can get to some sort of forbearance agreement or settlement agreement, and then you make it a condition as part of that agreement that they give you a power of attorney or authorization to enter onto the premises to take the collateral. That way, when you do it, and if they ever then spout off and say, hey, you did something wrong, you can go back and point to a document that says, hey, you explicitly gave me permission to do this. I'm within the letter of what you allowed me to do. So anyway, interesting case there. Number 4, Tom, preferred ship mortgages. What on earth is a preferred ship mortgage?
Great, thanks, Mike. And I might ask you to do an encore of your reenactment of that case if there's time at the end. We'll see how that goes. This is a little bit more dry as far as the topic, but it's very important. And this is the only quiz we have today that isn't tied to a particular case. So this is more of a reminder that not all collateral is UCC collateral. So open-ended question here a bit. How do you perfect a lien in a boat or a vessel that's larger than 26 feet and it's titled and registered with the U.S. Coast Guard? And the answer is the filing of a preferred ship mortgage with the U.S. Coast Guard. So titled vessels that have been registered with the United States Coast Guard have to, if you want to take a lien on those as a lender, has to be done through this federal law, this federal scheme. And the document is called a preferred ship mortgage. That's what the federal law how it's referred to. And preferred, I think, because it has certain preferences over other types of maritime liens could be filed with respect to that vessel. I've dealt with these on and off over the years in my practice. I've had some situations where the lender was actually making an acquisition loan for a purchase, and the vessels were brand new vessels. They were first being constructed and actually had not been yet issued numbers or titles through the U.S. Coast Guard. So we had to organize a process where everything was coordinated, and once the vessels were titled, effectively the bill of sale and the title registration and the lien, the registration of the lien, happens all at the same time. So the lien does get recorded against the title, very, very much like in state law with where liens are recorded against titles of motor vehicles. So if you've got something smaller, it's a vessel that's not registered with the U.S. Coast Guard, then this body of law probably doesn't apply, right? In fact, I live on an extremely small lake, think very small. And I have a small fishing boat, aluminum, I think it was built in like 1965 or something, titled with the Illinois Secretary of State's office. Well, if I wanted to, well, there's no value in it, but if there was and I wanted a loan, the lender wouldn't perfect with the Coast Guard. They probably would have to go to the register their lien on the title. And other things to keep in mind here, aircraft, also a federal system. And I think that office is down in Oklahoma City. We've got folks in our firm who work on those. and also railroad cars. The perfection could be different as well. So just keep in mind the type of collateral. UCC doesn't apply to everything, as we all know. With that,
Maybe,
I am gonna, yeah, go ahead, Mike.
Tom, yeah, maybe a quick rule of thumb is if you think that your collateral might be regulated by some federal regulation, you want to pause, especially if it's really unique, you maybe want to pause and say, hey, do I need to be perfecting somewhere other than the traditional venues for perfecting? And I think we've hit the big ones here: airplanes, railroad cars, large boats. But just want to put this on people's radar to be kind of thinking about it.
Yeah, there are also some international law considerations as well. I think particularly with aircraft, but if there's vessels that could be leaving coastal waters and going into international waters, there might be some other considerations there as well.
Yeah, good point. In the country of origin where it's at. So,
yeah.
All right, Chris, tell us about judicial mortgage foreclosures.
Will do. And just to comment on that last one, I remember in my admiralty class, if anyone refers to a seagoing ship or vessel as a boat, an admiralty lawyer will yell at you and say it's not a boat. What you're rowing in is a boat. If it's an ocean ship, it's a vessel. So, on to quiz 5. Loan documents require a lender, loan servicer, to provide a notice of default before the lender may demand payment in full. In foreclosure action, the loan servicer attaches a notice of default, attaches an affidavit that it was sent to the borrower, but there's no evidence presented that it was sent by first-class mail or received by the borrower at the notice address. Can the loan servicer prevail on summary judgment for foreclosure? No, it cannot. And a little more detail on this particular case. What the lender submitted was basically an affidavit from a corporate representative saying all the usual things. I have personal knowledge, and yet with respect to the statement about the notice having been sent, the court said, well, you've referred to business records, but you haven't attached them. And so at least in the consumer context, when these letters go out, there'll be a note in the servicing records, and probably in the business context as well. So if for example, you don't have any record like like certified mail receipt or a FedEx tracking number, and you have sent it first class, be sure that in your servicing records, there's a note there, because then in that particular case, an affidavit that the notice was sent might actually work. And the lender probably still would have lost in this case. One thing we haven't addressed in our quiz is that the court was also very troubled by the fact that the copy of the promissory note that was attached to the summary judgment motion, and I think to the complaint as well, had several allonges which were undated, and one of them I think was unexecuted. And it's a good reminder that this is a New York case, and New York has not adopted revised Article 9, which is 1990. And so that's important if you've got any negotiable instrument that has allonges attached, because in 1990, there were many changes to the Uniform Commercial Code. One important one in terms of Article 3 was that with respect to allonges, the drafters relaxed the standard. So prior to 1990, if you had an allonge, it needed to be, quote, firmly affixed to your negotiable instrument, which generally meant glue or staples. And after 1990, it just said affixed. And so, for example, courts, at least the modern trend is courts have said, well, if your collateral file has the allonge in it and it's not stapled or paper clipped to the instrument, that's still okay. As long as the allonge identifies the, for example, the address of the property or the loan number, or the amount of the amount and date of the original instrument, as long as there are those identifying marks, we're not going to hold you to that strict standard. But again, New York has not, and I'm sure some other jurisdictions, they still have that requirement of firm affixation. And I should also note that since we're in Missouri, Missouri adopted the relaxed standard in 1992. However, there are at least a couple cases since then it's just in dicta, but a few courts after 1992, when Missouri adopted the revised UCC, that say firmly affixed, even though it's kind of dicta, it's not the central issue, but believe me, you don't want to be the test case for that. So definitely watch the affixation requirements. And some of our key takeaways you've seen, read the documents carefully. If you have to notice up a certain way or to certain parties, a lot of times you'll have to copy attorneys from certain loan documents. And best practices is to use some kind of method that has a proof of delivery, or at the very least, some kind of tracking number. So FedEx, certified mail, that sort of thing.
And Chris, I guess a point on that point, and this is just a little tidbit beyond just this quiz, but when I was a younger attorney, I always thought, I'll always send it certified mail. It's USPS, it must be official. The thing I've learned just with years of practice is certified mail is just a pain in the rear. It's slow. It takes forever to get back. FedEx, UPS, it's instantaneous. The next day or 2 days later, whether or not you had proof of delivery, it's from a national carrier. And I've become really down on certified mail unless it's absolutely required by law or by the documents. I'm really big on FedEx or UPS, just because you get instant proof. And the problem is if you send something in the mail and then they say, hey, I didn't get it, there is a presumption in the law. But when you're going to be spending tens of thousands of dollars fighting over something, why not incur 15 or 20 bucks extra, send it via FedEx, and then you've got proof of actual delivery, and that way they can't raise these bogus arguments about, I didn't get notice or whatever else. So anyway, that's just a general practice tip that I've really come to be a big believer in over just years of practice. All right. We need to pick up the speed. We're only on quiz 6. We have 16 to go total. We only have about a half hour. So, all right, we're going to talk about collusion and conversion of AR. So this was a case that came out of Illinois. And what happened here, excuse me, not Illinois. Next one's Illinois. This one's Ohio. So you have lender number one. They have a previously filed UCC financing statement with a blanket lien in AR. You have lender number two who comes in and gets really sneaky with the borrower and the guarantors. And the gist of what happened here, it's kind of embedded in the question, but the gist of what happened here is lender number two comes in and says, hey, I'll do this factoring agreement, but I'm not going to file my UCC financing statement, but I'm going to do the factoring, and then when you collect your AR, just send it straight to me. And so there was this agreement with lender number one finds out about it. Lender number one is obviously very livid about the situation, rightly so, I should say. And so the lender number one files a claim arguing that there's been collusion and conversion of AR. And the question is, was that in fact the case? The answer is yes, there was, or at least the lender pled collusion and conversion of AR. And some of the key takeaways here, conversion of collateral is a pretty sensitive subject to a lender. And I think there's a little bit of a gray line, especially if you're a lender with a blanket lien in assets and AR in particular, right? Cash is the lifeblood. So the cash comes in, and then you get the borrower making the argument that, hey, listen, if I don't pay these unsecured creditors, then the business craters and it implodes. And sometimes there's actually a lot of truth to that, but it's a gray line of truth in the sense that there are some critical vendors that are absolutely essential to keep the business afloat. But a lot of times there are friends, buddies, whomever of the borrower who, in the true sense of the word, are not truly critical vendors. It's just the borrower wanting to try to help a good friend or something like that. And I know I've had this discussion, I can't say how many times with bank clients where the banker is livid, rightly so. Hey, that's my collateral. Why are you taking my collateral to pay unsecured creditors? And it's frustrating. And candidly, I think, we don't control the cash. It is our collateral, but I think the practical reality is the best defense to a situation like that is make sure that you have sufficient equity in your tangible hard collateral that they just can't immediately liquidate and kind of put the cash away, but I realize that's a perfect world situation. We don't live in a perfect world. But you want to try to, clamp down on this when it happens. And the key thing when we're getting into conversion of collateral is we really need to be looking for facts or something to show that there's this collusive type behavior, that the borrower, the guarantors are getting really cozy with whomever else may be out there about the collusion of collateral. And then the more facts that you can gather, that's going to strengthen the lender's case to come back. Now, I'll just say this parenthetically. I've seen this a few times over the years. I actually saw it, I don't know, within the last few weeks. I've seen a few hard money lenders, when they file their UCC financing statements, they will, do their collateral description, but then they will say, on top of that, they'll say, essentially, hey, we have a loan with the borrower, and that loan prohibits the borrower from entering into any other loan. And guess what? If you loan money to the borrower, that's forcing the borrower to breach his contract with us, and therefore you're tortiously interfering with our contract. And so they essentially do that as a shot across the bow, excuse me, to try to steer off loans and keeping the borrower not having this type of situation. It sounds a little heavy-handed. I haven't ever seen a case like that really litigate out, but that's a tactic that some particularly hard money lenders do to try to discourage the lending like that. All right, I say pick up the pace and then I just rambled. All right, so let's jump on here to number 7. Interesting case here. This one comes out of Illinois. The Chapter 13 debtor gets a plan confirmed, and the plan is going to pay for the lien on the car. And even though we're in a Chapter 13 context, you can see this applying into Chapter 11 or Chapter 12. So after the plan's confirmed, there's a car wreck. Debtor says, oh my goodness, I can't use this car anymore, so I'm just going to turn it back to the creditor, the secured creditor, give the secured creditor an unsecured claim, and I'm going to borrow new money to get a new car. The trustee objects to the situation, and the question is, can the modification be done? What do you think? Well, because we're in the bankruptcy world, your probably gut reaction is, yeah, unfortunately, the judge probably lets him do it. And that's the answer here. The court said that the debtor could do that. And as you see in my first bullet point, it definitely feels like the bankruptcy code is stacked in the debtor's favor. I think we all feel that way at times. But some more important points here is if you're dealing with a situation and there's a plan modification and it's impacting your collateral, and if you don't object up front, you're toast, because once that's confirmed, it's going to be binding on you whether or not you like it or not. And so you want to be careful about that. One practical tidbit I have found to be very, very helpful is that whenever I have a case, both Chapter 13 or 11 or 12, when the bankruptcy is filed, I always like to, like within the first day or two, if I have collateral, is I like to send a demand or request for proof of insurance. And the reason that's important is because a lot of local rules will say that if you don't have insurance on like these debtor consumer cases, the local rules put a stay in place where the debtor is barred from actually using the vehicle if there's no insurance. If they don't have insurance, then that also can start setting the groundwork to do a motion for relief from the automatic stay, because your collateral is potentially impaired and you want to protect yourself. So anyway, just a few tidbits on that one. In the interest of time, move on to number 8. Tom, I think this one's yours.
Great, thanks, Mike. And this one is fairly straightforward. Question is, we have 2 lenders. There's an intercreditor agreement. Lender 1 is disputing that lender 2 has a valid purchase money security interest in the collateral. Lender 2 is arguing that, even if they don't have a purchase money security interest, they still have a security interest. And the question is, who wins in that situation? And the answer here is lender two. So in this case, in the collateral description, the security agreement, there was an affirmative statement that that lender two had a purchase money security interest in certain collateral. And the other lender in this deal took exception to that, said, well, you didn't follow the rules. You didn't really have a purchase money security interest. Just because you say that's the case doesn't make it true. And they're right about that. We all know purchase money security interests require following certain rules, but the fact that this lender didn't have a PMSI didn't mean they didn't have just a regular security interest, and that's how the court held in this case. So in the end, they respected the inter-creditor agreement between the two lenders, and did not negate the security interest just for failure to follow PMSI rules. Of course, the takeaway is PMSI doesn't have anything to do with whether or not you have a security interest. In fact, the court felt that the inclusion of those words was superfluous in this case. It only has to do with the priority, vis-a-vis other creditors, other filers. And of course, if you do have a PMSI and want to claim it, follow the rules, which generally is making sure your filing goes of record within 20 days of possession.
All right, so Tom, I'm going to throw a question at you. So let's say I do a proper loan, I finance the acquisition of collateral, I properly perfect in 20 days, but my loan documents don't mention PMSI anywhere. Do I have a valid PMSI even though my loan documents say I don't mention a PMSI at all?
Well, I'm going to say that you do, because PMSI, again, state it affirmatively or negatively. It's a matter of following the perfection rules as opposed to what's in your documents.
Yeah, I agree. And I only say that to make anybody out there put you at ease. There's not like a magical word you have to get it or not get it. It's have you just complied with the basic rules? Yeah. All right.
Send it over, I think, to Chris.
Speaking of PMSIs, lender is originally a lessor of equipment to a borrower under a true lease. Borrower decides it wants to acquire the vehicles, and the lender agrees and sells the borrower the vehicles on credit and takes a security interest, a purchase money security interest. The lender has a valid lien in the vehicles, but the lien's not perfected within 20 days of the loan being made. Additionally, and this is in Kansas, the lender did not file a notice of security interest, because these are vehicles and you perfect by filing against the title. So borrower delays the filing of the paperwork with the Department of Revenue, and in the intervening time, the U.S. government imposes a federal tax lien on the borrower's equipment, including the vehicles. Lender's lien is subsequently perfected. Again, because the borrower did turn in the paperwork, just did it, took its good sweet time. Government argues that its lien now trumps the lender's lien. Who wins? The answer is the lender. This is the Dunn case. This was Mike and I's case where we represented BMO Bank against the IRS and won. And as you know, whenever the IRS loses, an angel gets its wings. This was governed by a revenue ruling, which says that if there is a subsequent purchase money mortgage or purchase money security interest, even if there's a pre-existing tax lien, it takes precedence as long as it is valid. The IRS argued that valid means perfected, and specifically perfected within 20 days. And we argued that no, valid means valid. A valid security interest is not a question of perfection under the UCC, but rather a question of attachment and enforceability. And the court ultimately did not reach that question. The court said, no matter whether valid or means perfected or not, BMO's interests were perfected, and we're not going to hold them to the 20 days that's set forth in the PMSI statute. The IRS did not get to sort of parachute in there and attach its interest. So key takeaways: don't rely on your borrower to perfect your lien, and it's always good practice to, even though things turned out in this one, always to file a notice of security interest, because the fact is that this particular borrower could have transferred the title. And if we had not, or if our client had not filed the notice of security interest, they would have been out of luck, because that would not have provided record notice to whoever got the title after the borrower. And so the only other thing is federal government litigation usually involves unique exceptions that can dramatically alter the case. This was certainly a strange one, and we were happy to get the win. And as one of our law partners said after we told him about our win, he said to me, "Congratulations! Enjoy your audit next year." So I will pass it on to, I believe, Mike again.
All right, Chris, I guess that gets quote of the day. Whenever the IRS loses and another angel gets its wings. All right. Anyway, so now let's talk about the automatic stay and the tolling of statute of limitations. So this was an interesting case coming out of New York as well. The facts will set the stage. It's here in the question. You have this lender and the borrower. They enter into a loan agreement secured by real property. But guess what? The borrower then transfers the property to an LLC. All of this is pre-petition. Borrower then files for bankruptcy, obtains a discharge, and then later on the lender tries to foreclose on the mortgage. And the LLC argues and says, hey, guess what? The fact that bankruptcy was delayed, that didn't toll the statute of limitations as to me, i.e. the LLC. And the question is, who wins? Does the LLC win or does the lender win? What do you think? Well, the answer is the LLC, and the reason is because the borrower's bankruptcy only tolls the statute of limitations with respect to the borrower and not to the LLC. And this can create a little bit of a messy situation, because a lot of times you will be dealing with commercial and ag transactions, and obviously if you'll have affiliated parties somehow, and there's always transfers back and forth, blah blah blah, and it gets messy just because they treat them closely, or sometimes are really loose and fast with the corporate or formalities. Anyway, when just one of them goes into bankruptcy, the rule here is that the statute of limitations is not going to be tolled for the non-debtor. And so you have to be really cognizant of that, because that bankruptcy could drag on for a long time, which then puts you in this odd situation where the claim against one entity is tolled, but your claim against the other entity is not tolled. So what do you do in a situation like that? A, obviously you need to be cognizant of it, but then B, what you really need to do is pursue your litigation. Now, sometimes the claims are so closely interrelated that you almost feel like you have to sue the debtor. And so what you can do in a situation like that is file a motion for stay relief and say, Judge, we want to go to state court to adjudicate the claim. We won't collect on it against the debtor because that's going to be confined to the bankruptcy, but we need to be able to liquidate it. And courts a lot of times are willing to do something like that, because then that allows the claim to be liquidated. And then obviously if there's any liability to the debtor, it then goes into the bankruptcy court where the claim gets paid. So anyway, interesting little tidbit to keep in mind. This next one, I think it's Tom, it's yours as well. What do you want to tell us about the modification of a mortgage debt?
Yeah, thanks, Mike. So yeah, another mortgage case here, or Virginia. So the case came out of Virginia, which I think is a deed of trust state. I'll go ahead and read the fact pattern here, and then we'll go to the answer. So we've got a property subject to a lender's mortgage. The borrower died, and the debtor, in this case, Chapter 13 debtor, inherited the property that was subject to the mortgage. debtor's not in privity of contract with the lender. By that, we mean the debtor who ended up owning this real estate did not sign the note. That there was about $56,000 owed on the mortgage. About $8,500 of that was in arrears and payable. Debtor filed for Chapter 13 bankruptcy and wanted to keep the property, and so was looking to pay off that debt over time. The lender saying, "Well, we're not we're not involved. You don't have a claim here, or well, we're not involved in this bankruptcy. Basically, there's no privity of contract. Our contract was with the person who died and willed this property to you." All right. So who wins? In this case, the borrower. Now there is a little bit of a split on this one, but in this case, the court took the view that because the bank had an in rem, or so there wasn't a contract between these parties, but they did have an in rem or property interest here. The Chapter 13 debtor owned property that was subject to the deed of trust. And therefore, it was a claim that could be modified by the bankruptcy court, which is what happened in this case. And so going back to those terms, I didn't think I would use after law school in rem and in personam. This was a case where there was a claim in rem. We've got a interesting sort of second fact pattern here in bullet number 2. And we say common risk is for owners of a wholly owned LLC to quit claim the property to themselves and then file for bankruptcy. And could they take advantage of this rule? And probably, Mike, you could probably comment better on this than I could, but probably not, because that sounds and looks a lot to me like it would be a constructive fraud or fraudulent conveyance.
So, yeah, I guess, Tom, you're getting, because I'm the one who drafted this slide, and now you're getting a little bit of my jaded commentary on this. And I'll just say, and all right, so this is Mike Fielding on a soapbox for just a brief moment, just to talk about risk, of course. I had a scenario like this years ago where it was exactly that scenario. And I think it was definitely more common before Subchapter 5 bankruptcy cases came out, because you had the absolute priority rule. And so what you would do is get into situations where the owners, they own the LLC. They're like, oh, I've got too much debt. So they just transfer all the assets from the LLC to themselves, maybe to the husband and wife, and then file for bankruptcy. And to me, it really bothers me, because from a state law perspective, that's a constructively fraudulent conveyance. I mean, you have this LLC that's just transferring all these assets to the owners of the company for no consideration, just leaving the creditors in the dust. And that new bankruptcy estate really has assets that are, on a certain sense, procured by fraud, admittedly constructive fraud. Question is it done with intent to hinder, delay, or defraud creditors? And I remember having an argument with the bankruptcy judge on this, and he ruled with the majority of the cases. We didn't like it. We appealed it to the district court and vehemently argued that the bankruptcy court was wrong. And then we had a family member that came in and essentially paid off the bank just to end the appeal, which was nice in that regard. So we got a successful resolution. But there's some dynamics or some tension right there. And the point here is that even though, bankruptcy courts may construe it a particular way because of this Supreme Court case that the Stevenson decision relied on, as a lender, we need to, frankly, be protecting our rights. And when there's something that's just wrong, we need to challenge it and do it appropriately. But sometimes when you challenge it, you end up getting, at least in that situation, you get a resolution in the case. All right. Now, I mentioned at the very beginning, marshalling, right, and how this is pretty unique. So this I got to give it here to lender number 2. Kudos for thinking creatively. So lender number 2's number 2 position in collateral. This is admittedly Chapter 13, but candidly, you could see this coming up in a Chapter 11 or Chapter 12 as well. So the debtor's trying to use 13 to strip the lender's lien. Lender says, whoa, hold on there. There's a lot more collateral that lender number 1 has, so we need to use marshaling and force lender number 1 to be paid from other collateral. Therefore, I am now in the money, and I, as number 2 lender, should be can be paid off. So you can't strip my lien. And the question is, can marshaling be used to defeat lien stripping under 11 U.S.C. 506A? Well, the answer, according to this bankruptcy court, is no. This comes out of Florida, and the bankruptcy court here really did a plain language of the statute and said, well, I don't care, sorry, tough luck. The statute allows for it. There's nothing in there about marshaling. You're out of luck in that situation. And I get how the bankruptcy court ruled, from a strict constructionist approach. It's hard to argue with it when you view it from that lens. But at the same time, we got to give kudos to the lender number 2 for making the marshaling argument, because it is, quite frankly, a pretty clever argument. And let's face it, a lot of disputes don't end up in bankruptcy. A lot of them are out of bankruptcy. And if you are out of bankruptcy, the marshaling doctrine is well and alive. Courts recognize and apply it. So let's say maybe you are in a receivership context. Well, then you have a much stronger argument there that marshaling can be invoked so that lender number 1 has to get paid from whatever collateral. Now, let's flip the tables. Let's say that you are lender number 1 and you have junior lien holders saying, hey, lender number 1's fully secured, so I should get paid from the AR, and lender number 1 should just liquidate the building and then get paid in full. And as lender number 1 don't like that, because we don't want to allow some cash to come in the door with the hope or this false belief, or I shouldn't say false belief, this hope that later on the building sells and that we get paid in full. And I think the argument there is that, you know what, lender number 1 is in a first position, and lender number 1 can go after whatever cash it wants, and it doesn't necessarily, this is the counter argument to marshaling, which is I get to get the first cash in the door to pay me off, and if it happens to come from this source, fine, then we'll deal with things after the fact. So you can see kind of the tension there that's at play. Obviously, the resolution is going to depend on your particular facts and circumstances. All right, I just looked at the clock, and we are 8 minutes, and we've got 4 more to go. So, all right, speed round, guys. All right, number 13.
Franchisor and franchisee enter into a business relationship. Franchisee signs promissory notes promising to pay the franchisor various monies. The notes require the holder of the notes to look to other documents to determine the amount of monies owed. Do these notes qualify as negotiable instruments under UCC Article 3? They do not. A negotiable instrument has to be an unconditional promise to pay a specified amount, and because the amounts could not be determined from the 4 corners of the document, the court said these were not negotiable instruments. And that mattered in this case because of a statute of limitations defense. Normal contracts in Pennsylvania, the statute of limitations was 4 years, whereas under the UCC for promissory notes, for negotiable instruments rather, it's 6 years. I know we're in the speed round, but for those of you in the commercial space, the consumer space, this issue, a related issue, is going to come up in the next few years with home equity lines of credit. There is currently a jurisdictional split on this question. A HELOC usually has a limit, up to $25,000 or something like that. But often it doesn't have the specified amount because, again, it's a line of credit. And Florida has many courts in Florida have said that is not a negotiable instrument because it doesn't satisfy an unconditional promise to pay a fixed amount of money. Other jurisdictions have gone the other way. So if we have a lot more mortgage litigation in the coming years, expect that HELOC question that's related to this issue to come up. I've also got the next one. Quiz number 14, consumer lenders' loan documents call for arbitration to resolve disputes. And by the way, they don't specify with which arbitral panel, so AAA or USANM. And it provides that the applicable arbitration form rules will be binding. So borrowers in this case made demand and said, we're choosing the AAA with consumer rules. The lender didn't object, but also for consumer cases, the lender had to register with the AAA as a consumer lender, which it didn't. And so the AAA kicked the case out, said you can only use our consumer arbitration if you, the lender, register. The borrowers then go and sue, and the lender seeks to compel arbitration. And can they do so, or does it stay in state court? It stays in state court. The court held that because the lender didn't object, and because the letter from the AAA said that the reason, or that rather the lender had refused to sign up with its registry, and therefore they were kicking the case out, that opened up the borrowers an opportunity to go ahead and proceed in state court. And some key takeaways: arbitration clauses are becoming more prevalent. Definitely want to specify which arbitration institution you want to use, be it AAA or USANM or some of the smaller ones. And because if you don't, you will allow borrowers and more entrepreneurial counsel to exploit any loopholes that might exist. So I'm now going to hand it to Tom for the next one.
Thanks, Chris. I'll go really quickly here. So 2017, a city did a bond issue. And when they did that, there was an ordinance that's typically done authorizing the issuance of the bonds. And then the city later filed for bankruptcy in 2022. The issue here is whether the general rule under Section 552 of the code, of the bankruptcy code, applied, which would cut off post-petition acquired property, in this case revenues that the city was continuing to get post-petition. And so the argument here by the lenders was, well, that rule doesn't apply because you have a statutory lien. City, you issued an ordinance, and that looks a lot like a statutory lien as opposed to a voluntary or consensual lien. But the court did not agree with that. They applied normal 552 consensual lien rules. And this was a Chapter 9 bankruptcy, something we might be seeing more of here in the future. All right, Mike, let you take the last one.
All right. I knew we were going to be out of time, so I didn't even bother with the question, right, when I drafted this. All right, here's the key point of this case. This comes out of Kansas, Chapter 12 case. They tried to recharacterize some payments previously made. Court said no. But here's the really important point out of this case. Here's the practical takeaway for any of you lenders out there. When you're negotiating with the borrower, you reach an agreement, and then they had in their settlement language this settlement anti-modification provision. And essentially the language was, hey, we're going to include our settlement as part of the Chapter 12 plan, and the settlement can't be modified absent consent from the lender. And so then the debtor later on, confirms the plan and tries to modify it, and they wanted to essentially mess around with some of the payments going forward. And what the court ends up holding is they said, hey, it's a matter of state law, and debtor, once you had that anti-modification provision in your language, and once it became part of the plan, you might be able to modify other parts of the plan, but you cannot modify your plan vis-a-vis the lender. And so this is a great example of how because this happens so often, you get into a dispute with the borrower, you eventually reach a compromise, it's reduced to a settlement, and then it becomes part of a plan that they try to confirm. You want to make sure that you have some sort of anti-modification language that's included in part of that, essentially trying to loop into this case so that when things go south with the borrower next year or 2 years down the road, that the borrower can't come in and stab you in the back and try to renege and get out of the deal, right? And the only way we want to allow that is if we consensually agree to a modification. All right. There's some notable cases at the very end. Not going to really spend the time in going through those. They're in the materials that you have there for the program. I will say this, we do this as a quarterly webinar, and our next one's going to be in the latter part of June. We'll be sending out an email alerting everybody about that, and it will be covering, you know, the latest and greatest developments in commercial and distressed debt, with obviously what we have here with our practical takeaways. Okay, final points here today. Just as a reminder, the program has been approved for legal education hours. You have the CEU icon at the bottom of the screen. The certificate of attendance will be emailed to you tomorrow along with the recording. Please, por favor, if you could give feedback on it. There's a short survey that will be sent. We really appreciate getting the feedback. Tell us what we did well. Tell us what we did bad. Let us know how we can improve so that we can try to make this more beneficial and useful for you. So with that, that concludes our webinar for today. Thank you for attending.